Whether you are at home, at church, or at the bar, cops may be tracking your every move. How? Cell site simulator technology. And this technology is really good at finding you. Like many law enforcement technology applications, cell site simulators were first developed by the military. But once law enforcement figured out how powerful they were, they began to figure out how to use it to track your every move. How effective is this technology? These cell site simulators can actually track you down to the very room you are in if you have a cell phone, which everyone does. To simplify what this technology does, think of it as technology that takes your cell phone and everyone else's cell phones and turns it into homing devices. Some people have referred to this technology as either stingray devices or hailstorm devices, because those are the names that many of the manufacturers have given to this type of technology. Whether you realize it or not, your cell phone is sending out tracking and GPS signals in order for your phone to be able to operate. This technology allows cops to capture your cell phone text messages, as well as incoming calls and numbers you are dialing out for outgoing calls, as well as other intimate details you have on your smartphone. Let's break this down. Let's say you're sitting at an NFL football game, and as you're sitting there watching the game, your cell phone is constantly tracking, looking for the nearest cell tower so that it can maintain your cell service. Now I want you to imagine a police officer that wants to track your every move through your cell phone. Let's say that he has a Stingray or Hailstorm device mounted in his Yukon, and now he's looking to try to track your phone. The Stingray device acts as a cell tower decoy and tricks your phone into believing it is the closest cell tower for your cell service. Once your phone dials in on the Stingray device, cops can now access most of your personal information and all your text message and outgoing and incoming calls. Here's the crazy part. Not only does the Stingray device trick your phone into connecting to the Stingray, but it also tricks anyone else's phones within its reach to also connect to the Stingray device. What does this mean? That means the cops can now get access to any other phones that are tricked to the decoy of the Stingray device. You say, wait a minute, I'm confused. What if I actually take a phone call? How does that work? Well, here's where the Stingray gets really tricky. It actually sends the actual communication and the cell phone call to the true cell phone tower so that you never lose any service. But at the same time, it's gathering all your data and all your information so that the cops can track you and know exactly where you're at. Now, cops justify the use of this technology by claiming they're only targeting certain individuals' phones. But unfortunately, the technology doesn't work that way. Instead, these cell site simulator devices, they trick everybody's cell phone within its reach, and they are now able to gather everyone's personal information, and we are supposed to just trust that the police will not misuse or abuse this information to violate our privacy rights. Police departments have been using this technology all over the country, and they've been doing so for years, but they're very tight-lipped about it, and they don't like to talk about in what capacity they are using it. In fact, at least 75 agencies in 27 states have purchased this technology, and they are actively snooping on you right now. Here is the crazy part. Nearly every federal agency, including the IRS and the ATF, have used this cell site simulator technology like the Stingray to snoop on people all over the country. How do we not know more about this technology? Well, primarily it's because law enforcement agencies have signed non-disclosure agreements regarding not only the purchase of the technology, but also the subject matter of the technology. And they signed these with manufacturers. Why do they sign them? So that way none of this information is made available to the public. Think about how crazy this is. We learned from the case of Andrews versus Baltimore City Police Department that the FBI and other agencies have entered into a non-disclosure agreement with these manufacturers from disclosing, I'm going to read exactly what it says, from disclosing, quote, any information concerning the simulator other than the evidentiary results obtained through the use of the equipment. In other words, only the evidence gathered from the use of the technology can be talked about in court, but you're not allowed to talk about how the technology actually works even in court. Now, personally, I think that's garbage. If these courts wanted to invalidate these non-disclosure agreements, they absolutely could for use in a courtroom. Why do I say this? Because courts have used the lack of transparency about how this technology works as an excuse to not rule them unconstitutional. Courts claim they cannot gauge the level of intrusiveness of the device to do an adequate Fourth Amendment analysis. Now, are cops required to obtain a search warrant in order to use anything they receive from one of these Stingray devices? It depends, and I will answer that here in just a moment. But here is the real problem. Even when cops do obtain a search warrant, very little is made available in public record about these warrants or how the police chose to use this technology.
Basically, that's all I'm going to say about it. You know, when a general goes in battle, he doesn't give out his battle plans.
But what about innocent bystanders whose privacy is violated by the cops when they choose to use this technology?
As long as we do it lawfully, I don't care what people say. My job is to keep people safe.
So here's the big question. Is all of this legal? It really depends on if we are talking about a federal or a state criminal investigation. For years, both federal and state law enforcement used this technology without obtaining a warrant. Even when they would obtain a warrant, they would many times describe this technology in very misleading terms in order to make it seem less invasive. They would often refer to stingrays in court documents as pen register devices. Pen register devices are very different. They are very passive devices that sit on a network and they record phone numbers that come in from a certain phone. The feds would often withhold the fact that these devices force phones to connect to them. They would also withhold the fact that many times it forces other phones that are not a part of the investigation to also connect to them. And they would fail to inform the court that these devices do much more than grab a person's phone number. Most significantly, they would fail to disclose to the court that these devices emit a signal that allows them to track not only a cell phone, but track the user of it within their own private residence. We have been covering how the government is using spy technology to track your every move. But what if I told you that the problem goes beyond the government? Because in reality, there are people who are privately snooping on you, trying to take advantage of you. Whether you know it or not, there are people sending scams to your email inbox. And there are people calling you based upon someone selling your information to a marketer. And now they're driving you crazy with phone calls, or worse, they may try to bait you into a phishing scam. For me, my email inbox gets more suspicious and scam emails than ever before. I know marketers and con artists are tricky, and they find ways to buy my data and my contact information from marketing campaigns and websites that I've signed up for in the past. But more important than my email inbox are these crazy phishing calls that I get from marketers trying to claim that my extended warranty has expired and that I stand to lose everything in a car accident. This was driving me crazy until I realized that it is virtually impossible to live in the digital age that we're in without sharing some of our contact information with other people. Whether it's signing up for newsletters, a website, or just making a trusted purchase online. The problem is this: we have all seen the notifications from trusted companies saying that they apologize to their customers because their data may now be compromised because they have been hacked. To make sure that you are not victimized, this is where Incogni steps in. Incogni is one of the best in the business at doing one thing: monitoring and removing your contact information from these lists. Incogni works tirelessly to have your information removed from these marketing lists. If a company refuses to remove your contact information from their database, this is where Incogni steps in to make sure and get you over the finish line so that your personal information is safe and that you're protected against these phishing scams. Look, if you are like me and you want to avoid the police from violating your privacy, you also want to protect yourself from shady marketers and scam artists from violating your privacy as well. Incogni has a special offer for all of us. In the attached link and in the description below, you'll see a special offer of 60% off the normal price for Incogni. And I can speak to this personally. It's worth looking into and certainly worth investing in. This channel would not be possible without great partners like Incogni. and I appreciate the great work they do protecting us. So check out the link below and take advantage of this great offer. The link is incogni.com/Hampton Law. Back to these cell site simulators. Let's look at an example where the feds used a stingray device to track somebody down and arrest them. In fact, the FBI used a stingray device to track down Rig Maiden, who is actually a San Jose identity thief. They tracked him down to his apartment. But during the actual trial proceedings, Rig Maiden's attorneys were able to get the Justice Department to admit that using a stingray device qualified under the Fourth Amendment as a search. So as a result of that, it should require a warrant. Law enforcement agents have not only deceived judges, they've also misled criminal defense attorneys regarding how they've used these devices to track their clients. In some court documents, law enforcement officials claimed they were using a confidential informant in order to obtain location information about a defendant. But in reality, it was learned they were using a stingray device to track the defendant to his location. In 2015, the Justice Department instituted a new policy requiring all federal agents involved in criminal investigations to obtain a probable cause search warrant if they are going to use a stingray device. The policy also requires both agents and prosecutors to tell a judge when the warrant they are seeking is for a stingray. The policy also requires that if you're going to use a stingray in a criminal investigation, that you must limit it to using it to gather information about the target phone and numbers being brought in and dialed out from that phone, and not to collect information from other phones. Agents are not allowed to collect text messages and emails through stingray technology, and any information they obtained from non-targeted phones must be purged within 30 days. Here's the problem. Justice Department policy is not law. So even though the Justice Department may claim they are going to abide by these rules do not apply to any state or local law enforcement agencies using stingray technology, unless that local agency is also working with the feds. So that means local and state authorities can continue to use this technology with no regulation. Some states like Utah have passed some legislation to limit police from using technology in a way that could violate our privacy rights. In fact, Utah's law says specifically that law enforcement cannot use this stingray technology to gather anybody's personal information unless they have a warrant. The problem, it's virtually impossible to know if you have been targeted by stingray technology unless the government tells you. And we all know they're never going to tell you. What if you live in a state that has not passed this type of legislation? What about the Supreme Court? Have they ruled on this? Unfortunately, no. Now, in a long line of Supreme Court cases, the Supreme Court has long directed lower courts to always take a look at law enforcement technology through the lens of how much that technology creates a degree of intrusion into our privacy. In fact, in Berger versus New York, the Supreme Court rejected the use of eavesdropping devices by the government because actual conversations of people near the device were collected indiscriminately. In Katz versus US, the Supreme Court also stated that the government must be careful using electronic devices to ensure that there is no greater intrusion in privacy than necessary. In fact, in Maryland versus Garrison, the United States Supreme Court stated that the Fourth Amendment should, quote, place obstacles in the way of too permeating police surveillance. So here is our current state. Currently, the Supreme Court has not ruled on this issue, and the federal government may have a policy in place, but that policy is not law and it does not apply to the states and local government. So unless your state passes a law like Utah limiting law enforcement from using this technology, your state and local governments may continue to use this technology to violate your privacy rights. Here's what needs to happen. Lawmakers need to pass a federal law requiring a valid search warrant to be in place before law enforcement can ever use this technology. In fact, there is a bill before Congress right now to address this issue. It is known as the Cell Site Simulator Warrant Act of 2023. But as you can see by the bill tracking website, the odds of it currently passing are 0. Oh, by the way, another big problem with the Justice Department policy regarding this technology is that they have certain exceptions that don't require having a warrant. For example, this policy only applies for criminal investigations, but if it involves national security, which the government can claim almost anything involves national security, then these policy rules don't apply. Also, they carved out another exception for what is known as exigent circumstances. In other words, if the feds decide they have an emergency situation for which they need to use this technology, now they don't have to follow their own policy rules, and they'll go ahead and use this technology without a warrant. So what do we know? We know that the feds, the ATF, the IRS, and local and state governments are currently using this technology, but not just to track criminal activity. They're gathering innocent bystanders' data and information, and we have no idea what they are doing with this information because they don't disclose any of it to the general public. Now, what can we do about it? First of all, call your local congressman and tell them you want them to vote for this new passage of H.R. 6194, known as the Cell Site Simulator Warrant Act of 2023. If we don't do something about this, this will die in committee and it will never pass. Now, people ask me, Jeff, does this bill fix everything? No, it's not perfect. But one thing it does do is it will require both the federal, state, and local governments to obtain a valid search warrant before they are ever able to use this type of technology to violate our privacy rights. Now, if you think this is bad, did you know that Congress has already passed the 2021 Infrastructure Investment Jobs Act? And as a part of that bill, they are requiring all auto manufacturers to install alcohol detection devices with kill switches on all new vehicles. Check out this video where I break down exactly what the law requires and what the government is going to do with your data. See you over there.